then let's see, did it start? It is recording. Okay. Just one final reminder for those of you, again, who are just joining us, please be sure to sign in to the chat with your name, school district, and or agency that you are with us for joining us from. Sorry, my brain is not quite working right now. However, without further ado, I'd like to introduce Paige Jokey from the Education Law Center of Pennsylvania. Go ahead and take it away, Paige.
Hi, good afternoon. Thank you so much for the warm introduction and welcome. My name is Paige Jokey. My pronouns are she and her, and I'm a staff attorney at the Education Law Center in our Philadelphia office, where I specialize in supporting young people experiencing homelessness and their families, and I lead our Black Girls Education Justice Initiative. If you haven't yet heard about ELC, we are a legal services nonprofit, and our mission is to ensure access to quality public education for all children in Pennsylvania. We have three priority areas: access to quality schools, adequate and equitable school funding, and dismantling the school to prison pipeline, also known as pathways to confinement, which describes a phenomenon that things that are happening in and around school becoming drivers for entry into systems for young people and their families. We have an ambitious agenda today, and fear not, I will not leave you without resources. If you have questions, please do raise your hand, drop them in chat, or otherwise let me know. You will not interrupt my flow by interrupting me, and I encourage you, please have lunch, stand up, stretch your legs. I also respond pretty well to nonverbals, so if there's something you're agreeing with, something that I'm not explaining clearly, if you can just give me the look, usually I'm pretty perceptive at understanding where to go from there in terms of explanation. So here is what we'll be accomplishing today. We'll be discussing school enrollment, Act 67, the star of our show today. I'll be going over some resources and then having a designated time for Q&A. Again, please note, questions are welcome throughout. And also, if your schools are doing something that you're really excited about around Act 67 or McKinney-Vento or any of the other topics that we're talking about, please do share. We at Education Law Center are always looking for models to uplift, and I think that bringing groups of folks together who are experts like this group is a really informative way to best protect Pennsylvania's children and their rights to an education. So I wouldn't be doing my job as an attorney if I didn't give you the legal disclaimer. Sorry, let me get this out of your way here. Please contact your school solicitor or attorney with any specific legal questions or advice about the rights of students and families under law. I can answer general rights-based questions, but I can't answer specific questions regarding individualized students in your districts. Please do reach out to your school's attorneys for that. It feels like next school year is already upon us. And so I wanted to begin with just some very basic primer on school enrollment. So just a refresher. So generally, students age 6 to 21 have a right to education, and students who turn 21 mid-year, like I'm a January baby, would have the right to continue to attend school until the end of that academic year. And if they're eligible for special education services and receive extended school year, ESY, they would also be eligible for that period. And due to a recent settlement negotiation with the Pennsylvania Department of Education, young people who have IEPs, individualized education programs, who are entitled to special education, can remain in school until their 22nd birthday. And all of the slides that you'll be getting are clickable. So if you're wondering, where did I get that? Where is the law? Where can I find that resource? Everything will be clickable, and I will actually update this PowerPoint with questions and answers from today's session. That way it's useful in real time or for folks that are watching this at a later date. So Act 67, one of the things it deals with is residency. So generally, children have the right to attend school in the district in which their parent or guardian reside. There are two really important resources from Pennsylvania Department of Education, PDE, and those are called Basic Education Circulars, which are the department's guidance on a wide variety of education topics. The two linked here are enrollment of students and education for homeless youth, which is their Basic Education Circular, their BEC on McKinney-Vento eligible young people. Notably, the concept of residency does not apply to students who are experiencing homelessness. There are also several other exemptions to the general rule that you generally go to school where your parent or guardian resides. And I am going to take the boxes going horizontally. So that would be students who attend schools or programs that don't serve specific catchments. So I see some of our partners from charters are here, our cyber charters, special admits schools. That would be one set of examples depending on the enrollment requirements. Children who split their time 50-50 between parents who live in different districts then get to choose, and then that choice remains for the school year unless somebody moves. Students who are enrolled through the 1302 process, where they're residing with an adult district resident who is supporting the child without compensation year round. If you're looking at the BEC for that, what you might see is the word gratis. That means free. That doesn't include things like public benefits or some limited other types of support, which is explained there and also in Education Law Center's enrollment fact sheet. Students who are experiencing homelessness or in care, I'm on the green box, who have a legal right to school stability if it's in their best interest. Students who have IEPs and 504 plans that attend a placement that can meet their needs when their catchment school can't. Students who are attending a different school for a disciplinary reason, such as expulsion or alternative education for disruptive youth. That is AEDY, not language that we at Education Law Center would want to use to describe young people. But if you were to look at what that acronym means and what laws apply, that's what I'm talking about when I say AEDY. Students who are in hospitals, residential treatment facilities, RTFs, or in the juvenile or adult legal systems, if narrow criteria are met, and children who have a court order specifying that they need to attend a specific school. So here is some information from the guidance around enrollment. And these are permitted proofs. So permitted proofs are what do you need to establish your residency? And this basic education circular was recently updated, and it's something I refer to frequently. Importantly, any one of the following are acceptable. That could be a lease, a deed, a utility bill, a credit card bill, a property tax bill, a vehicle registration, a driver's license, or a Department of Transportation identification card. That's the dot part. And any one of these is acceptable. Schools also must be flexible in verifying residency and should consider what information is reasonable in light of a family situation. Two things to remember. Some students will have a legal right to attend a particular school, even if they're not a resident or residing in the catchment. And the concept of residency doesn't apply to students that are experiencing homelessness. In the context of enrollment, these are some do's, here are some don'ts. So schools can't condition enrollment by requiring certain documents. So if you are looking at your school's policy and it says something like, you must have a lease, not allowed. You must have a birth certificate, not allowed. Some other examples that we see frequently are state-issued ID, photo ID, leases or deeds, birth certificate, or proof of citizenship. That is also never allowed, nor can it be asked about. You cannot ask about a student or parent's immigration status. Schools cannot require a passport or social security card, and schools can also not ask when a child entered the United States. If you're wondering what other things might be acceptable if a student does not have a birth certificate, because you can't require a birth certificate as the only document for proof of age, one that a lot of folks have really easily is a prior school record. And that could count for proof of age. And if there aren't documents that are listed, like a baptismal certificate, other types of proofs, you could also provide an opportunity for the parent to issue a sworn statement, an affidavit regarding the birthday of a young person. It isn't uncommon, as you know, when we're working with students who are experiencing homelessness in their families, or McKinney-Vento eligible students, as I call them interchangeably. Sometimes families have lost everything if they have been evicted or they've lost a storage unit. And so providing those free opportunities for affidavits can be really helpful. So here are some enrollment best practices. So these are things that we at Education Law Center have found work really well. And there are also things that schools that report back to us about what they're doing to best support children and families, and elevating practices that they actually do use. So screening first and often is the first one. So screening families for McKinney-Vento and Act 1 eligibility at enrollment and after every school move helps uphold children's legal rights and also make sure that schools are complying with legal obligations. When you do regular screenings and you're explaining why a screen is being used, it can help eliminate stigma if it's something that families are used to experiencing in the school. And this also helps clear up confusion because residency can be complicated. And so having this conversation early and often is really helpful. I know some school districts also will ask families if you are anticipating a move or if you are concerned about losing housing, letting us know in advance can be helpful to help streamline education and make sure a child isn't missing out. So if a student is not McKinney-Vento eligible, then figuring out what process applies. And this is a checklist that I use and practice regularly. So the first question that anybody would need to ask is there a court order? If yes, it needs to be followed. Are there any other circumstances that might diverge, that might exempt a child from residency rules? Ask your solicitor and see slide number 7 if you need additional reminders there. Is a parent or person with legal custody enrolling, or does a 1302 process need to be followed? We at Education Law Center also have a 1302 fact sheet. So if you're wondering about that and you want a handy desk resource, it is linked at the end of the PowerPoint. And ensure that enrollment documents are available in the enrolling party's preferred language and ensure that the translated versions are correct and actually say the same thing. So one example that I often see is in English, it will ask a question of, do you rent or own your home? Which is just one question, again, not outcome determinative for McKinney-Vento. We'll get to that in just a second. And then sometimes the version in Spanish will say, is the house rented or owned? So somebody may be answering those questions differently. So please make sure that the forms are actually the same. That way it is clear what families are or are not responding to. So Act 67, it is linked here in the subject line. And this is a new Pennsylvania law that is applicable now that amends the Public School Code, Section 1302, by doing a variety of things. The first thing is keeping children in school learning while a residency hearing and appeals process is going. Second, it clarifies the process that school districts have to follow before disenrolling a student who is determined not to be a resident, who otherwise doesn't have a right to attend, or was enrolled using a sworn statement that the school determined contained false information. It also ensures that families receive needed information on the federal McKinney-Vento Act before a child is disenrolled due to a residency dispute. And you might be wondering why there are 2 legal citations after the last, and that's because Act 67 has one process that it uses for if there's a non-resident determination and a different process if a student was enrolled using documentation that the school has determined contains a false sworn falsification. Sorry for the tongue twister there. And we'll go over each of those processes, but that's why there's 2 citations there. If you're wondering, where did I get that information or what do I cite specifically after each piece of information, that is a legal citation after it. Importantly, Act 67 does not change the way that a student may have a right to attend under federal or state law, including McKinney-Vento Act. And a quick note about 1302. So I shorthanded it a bit earlier in the presentation. 1302 is the section of the Public School Code that deals with residents and the right to free school privileges. A lot of times schools and myself will shorten 1302 or 1302 affidavit in the enrollment context to refer to the rights of students who are living with a non-parent who is supporting them as if they were their own, even though Section 1302 is broader and applies to the right to attend schools generally. So if you're using 1302 as a shorthand, just know it applies to more things. So I know we have liaisons on the phone with us today or on virtually. So thank you for all that you do for Pennsylvania students. It makes a critical difference. And I have the privilege of working with liaisons very frequently. So thank you for all the love and care and innovation that you pour into your jobs. One thing that is really important to know is that Act 67 doesn't take away McKinney-Vento at all. What it does is it actually provides an additional layer of McKinney-Vento protections for students insofar as making sure that families know about their rights. So it doesn't change that students must be treated as if they are eligible for McKinney-Vento protections until the end of the McKinney-Vento dispute resolution process, including all available appeals. After this process is completed, the school district could then proceed with residency proceedings in accordance with Act 67 if the child is not McKinney-Vento eligible and does not otherwise have a legal right to attend school, and both processes would need to be completed. There are many types of housing circumstances that are considered to be McKinney-Vento eligible, and that's a student who doesn't have access to, so they lack a fixed, regular, and adequate nighttime residence. And so here are some of these examples. The most prominent in terms of occurrence is living doubled up with a friend or family member or other due to economic hardship, loss of housing, or similar reason. It also includes folks that are living in shelter, substandard housing, in a car, on the street, in a place not ordinarily used for sleeping, living in a hotel or campground. One note about substandard housing, this is really important right now. That includes if, it's always really important, but this time of year, if a student doesn't have access to housing that can maintain a safe temperature, so in the winter, think really cold, so like lacks heating or cooling, is infested, doesn't have water, doesn't have an essential working aspect like a kitchen or bathroom. If you have an agency like licensing and inspections or a corollary, and they have found concerns with that housing and declared it substandard, those are all things that would count as McKinney-Vento eligible. So I promised a little preview earlier about the leases or deeds. Just because somebody has a lease or a deed doesn't mean that they are not McKinney-Vento eligible. McKinney-Vento eligibility turns on housing status, so there's no income requirement or cutoff, and renting or owning a home in and of itself isn't outcome determinative. So for example, a family could still be renting an apartment that is substandard, or they could be living doubled up with no legal right to remain in the property, but still be paying rent to either the landlord or somebody else. And so really having those discussions with families can be really helpful. I want to move on to one note about McKinney-Vento residency investigations, and then I'm going to pause for any questions in case there are any. So just a reminder, if a local education agency in LEA disputes a student's McKinney-Vento eligibility, the student still needs to be treated as if they're eligible and permitted to attend school until the end of the dispute resolution process, including all available appeals. What's really important is to screen for eligibility prior to initiating a residency investigation. And again, residency is not a concept that applies to McKinney-Vento eligible students. In many cases, in our experience, eligible students aren't properly screened, and then they are subject to an improper residency investigation. Also, in our experience, Black families tend to be subject to these proceedings and more regular and intrusive investigations. Importantly, residency investigations can be really traumatic and mimic violence from which families are fleeing, which might dissuade them from exercising their rights. So some schools used armed police, which can make families feel like they're in trouble, can also cause them to lose housing if somebody else is answering the door. And so schools should always exercise extreme caution when reaching out to family, friends, and others to confirm residency, and should provide notice about when this may happen. So let me give you an example. One of the very first cases I handled, the children were living in a hotel. They were in a confidential safe house that was renting rooms in a hotel. There was a residency investigation going on, even though the family was McKinney-Vento eligible, but somebody was calling in the dead of night and asking the front desk questions and was following the elementary age children in an unmarked car. Somebody actually called 911 because they were concerned that somebody would maybe be trying to abduct the children. But what was happening was a residency investigation. So just making sure that you're reviewing your policies and practices to make sure that fact gathering doesn't end up perpetuating trauma or forcing a family to lose a temporary and often very precarious housing situation. So I'm going to stop here in case there's any questions. And if there are not, get ready for some fun figures.
No questions in the chat page, but if anyone else has questions, please ask. All right.
Okay. Well, we're going to move right along then. One note. We, because this law is new, are working on our graphics. One thing, if you've ever watched me present before, thank you for coming again. And I'm not the best with technology or graphics. So if you are looking at these slides and you're like, I could do this much better, I welcome any feedback and support. So what we're going to do is we're going to go through Act 67, the two different processes. So this process is about students who are non-residents. And the next one is going to look similar, but it is going to be about if a child was enrolled using information that the school is determined to be false. So this is situation A. So what the law says is a school district is prevented from disenrolling a student determined not to be a resident and is not otherwise has right to attend school. This protection applies until A, a court order directing that the child be disenrolled and re-enrolled into another school, or B, the following process occurs. So remember, if there's a court order directing you're out of this school, you're disenrolled, and you're in another one, that would govern. If not, use this process. So step one is providing McKinney-Vento information. So at the end of the session today, Education Law Center has created 3 sample notices that your school can use and modify. We're going to share them with you in Word about this would be notice 1. So apprising families of their rights. So after information about the McKinney-Vento Act is provided in an understandable manner and form to the parent guardian person with charge or care by the district's McKinney-Vento liaison. So that's step 1. You'll provide McKinney-Vento information prior to the hearing. And either number 1 or number 2 happens. Situation A, I'm just going to say parent, but whenever I say parent here, I mean parent, guardian, person having charge or care of the child is provided with, just to shorten that. So the parent is provided with an opportunity to appeal the decision through a hearing held under the school's grievance policy. So your school should have a grievance policy and exhaustion of any appeal. If you're thinking like, this sounds a little bit like McKinney-Vento, it does. And so if you're thinking about similar systems, that's one way to think about it. Or number 2, after the parent guardian person having care of the child, again, I'm just going to shorthand that to parent just for this very moment. Other folks there are very important and have rights as well that are just as important and valid. For the purposes of this, I want to be sure I can be clear, are provided with notice of the hearing pursuant to the school's grievance policy, and they decline to participate in the hearing or appeals process. I will have a special slide at the end about what declining to participate means, because that's a question we've gotten a lot of. So we'll go over that. And appeals must be filed within 30 days of an agency decision. So this would be an agency decision. So within 30 days of receipt of the decision, the family would need to appeal. Does anybody have questions about this?
I did just pop that first notice, sample notice in the chat page, and I'll do that with the others as you go through.
Okay, thank you.
You're welcome.
So this is going to look similar, but this is situation B, disenrollment protections for students who the school finds were enrolled using a sworn statement containing false information. Again, court order first. Is there a court order that directs that a student be disenrolled out of one school and enrolled into another school, or the following process occurs? Again, McKinney-Vento information is provided, and either number 1 or number 2 happens. Again, number 1 is that the parent is provided with an opportunity to appeal the determination that a sworn statement used to enroll the child contained false information through a hearing held under the school's grievance policy and exhaustion of any appeal. Or number 2, the parent, broadly defined here, including parent, guardian, person having care of the child, is provided with notice of the hearing pursuant to the school's grievance policy, and they decline to participate in the hearing or appeals process. And again, this is an agency decision, so it must be appealed within 30 days. What are residency hearings? Well, they're formal hearings that are subject to due process protection. So what due process means is that a certain procedure needs to be followed before somebody could be stripped of their rights, which would include a right to go to school. A formal hearing requires notice by certified mail at least 3 days in advance, the right to be represented by an attorney or counsel at one's own cost, the right to be presented with the names of witness and copies of any affidavits, those are sworn statements written by witnesses, the right to request that witnesses be present in order to be cross-examined, and the right to audio or written transcript of the hearing, including a free copy if the family or student can't afford one. If you were looking at a policy, it might say indigent. That means that somebody is not able to afford that transcript and they need to be provided with one. right to a written decision of the hearing's outcome, and right to appeal the decision within 30 days. I can see the chat is moving, so I'm just going to take a quick peek here. Yes, the PowerPoint will be shared out. And thank you for your attention so far. I'm going to move us to any appeal here. In addition to the appeals stemming from the school's grievance policy, any appeals would also include an appeal stemming from the Pennsylvania Department of Education's enrollment complaint process, which I'll talk about in 2 slides from now, and an appeal of a court order or decision involving a student's entitlement to attend a particular school. Below are the resources to learn more about the Pennsylvania Department of Education's enrollment complaint process and a sample complaint letter that families could use to self-advocate that is attached to Education Law Center's fact sheet. When I've given this training before, there's been many questions about what does declining to participate mean? And here's what it means. It means after receiving proper notice of the hearing, the parent, guardian, person with care or charge of the child doesn't show up to the hearing and does not appeal the hearing decision within the time frame allowed. This means that the 30-day time frame for appeal must also have ended. And again, it's very important that they received proper notice. So for example, if they did not get certified mail, or if they were not told 3 days in advance, they have not declined to participate because they have not been provided appropriate notice. And also the timeline has not run for appeal. Does anybody have any questions about this part? All right. I am going to move us now to an overview of the Pennsylvania Department of Education's enrollment complaint system. Could I just get a show of hands or gestures? How many of you have encountered this process before? Okay, so this is a process that is coming out of the Pennsylvania Department of Education. What they're first going to do, whenever possible, is contact the school district or school representative, the person filing the complaint, and others involved within 5 school days. So sometimes that resolves it, right? There was a misunderstanding, information is gathered, things are sorted out. Sometimes that does not sort out what happens. So families and others are able to file a complaint by email, mail, fax, or phone. There are 2 email addresses. If you were to look on the Department of Education's website, the person directly who's handling them, and Monica, Washington, and also the address for school services. I've included both of the phone numbers, the fax number, and the mailing address. You would want to mail it to 333 Market Street in Harrisburg, zip code 17126. And the person who is filing the complaint needs to always send the complaint to the superintendent of the school district in which enrollment is being sought and keep a separate copy for their records. Sometimes families will say that they're going to file a complaint. Other times they won't. As long as they provide service to the superintendent and file in one of these ways, they are able to proceed with that complaint process. And if they're not sure what to do, if they call these numbers, they'll kind of walk them through what should be done. And if families are using our self-advocacy tool, it may look very familiar to the fact sheet resource that we're sharing out. So if you want to see what one of these could look like, it doesn't have to take that format. You can take a peek at that resource. I wanted to just go back over about what happens if a child is enrolled using a false statement. So Act 67 process is followed. The child is then disenrolled. You cannot enroll a child using a statement that you know to be false. That is against the law, and it is a summary offense if somebody knowingly provides false information in a sworn statement to enroll a child into school. If somebody is convicted of this summary offense, the person will be required to pay tuition to the school district for the time the child attended school when they did not have a legal right to attend. So if you're looking at the law, you may see period of enrollment. That's what that means. And subject to one of the following additional 3 penalties. So tuition plus one of the following. The first would be a $300 fine for the benefit of the school district, which the person resides, up to 240 hours of community service or both. So the $300 up to the $300 fine and the 240 hours of community service, up to. So it is extremely serious. It is not, you cannot enroll a child using information you know to be false. I have reviewed many enrollment policies, practices, procedures in my day, and usually there is something that families are signing that all of the information has to be true. And so that's, if there's like a citation to something on those policies, it's oftentimes to this particular statute. So making sure families understand what they're signing is really, really important, and ensuring that they understand the questions that are being asked of them is also really important. Sometimes families are told that they need to fill out one process or another to enroll. If somebody is telling you that they were told that they needed to fill out a specific policy or pathway to enrollment, I always ask them what information they got, because sometimes families are just confused, which leads to them filling out the wrong form, and then it causes confusion. And sometimes families can then be placed into Act 67 proceedings when really what needed to happen was the wrong form was submitted. So I know that enrollment can be something that's very challenging. So I always just double check when I'm talking with families, because sometimes there is confusion over what form somebody needs to fill out and what rights families have to attend school. I can tell you, in my experience handling many enrollment matters, that sometimes families have received the misinformation that they can choose any school they want to in the Commonwealth as long as it's a public school and that their child can go there. That is not what the law requires. And so providing that education up front, I think, is another really valuable resource and tool that we all have to make sure that kids are attending a school that they have a legal right to attend. So I have already shared a little bit about residency investigations, but just wanted to reiterate that while schools do have the legal ability to conduct a residency investigation, making sure that that is done with care is very important. I have some additional slides that I can cover on just refreshers for Act 1, if that would be helpful. I'm also happy to pause for questions if there are any, because I know that that was a lot of information.
Paige, I have a quick question. So in a previous district I worked in, we had a family that enrolled in our district. Then they moved to a cyber program, moved out of our district. We issued them, they claimed homelessness, issued them all the forms, actually the forms that you provided. We had the similar forms, certified and everything, never responded to anything. What is the next steps then? Would we have contacted the cyber program to say, hey, they're living in a neighboring school district, contact that school district? What's the next steps in that situation?
Sorry, I was trying to unmute myself and could not do that. That is a great question. So I think, can you see what does decline to participate mean? Okay, great. I wanted to pull back up this slide because I use it as a checklist. Okay, so you've done all of the formal noticing, you've given them the opportunity to appear, you have ideally reached out to them in other ways. So on our forms, you'll see like, do we have an email? Do we have a phone number? Not responding. So you provide notice, the hearing happens, they don't show up, the hearing proceeds, right? Because if a hearing can happen in absentia, which means that the family, when proper notice was provided, if they don't show up, it moves, it continues. Just like if you don't show up in court, sometimes it's going to be continued, other times it's going to proceed. So here, after providing proper notice, they haven't shown up, the 30 days happen, they haven't appealed. In the meantime, I take it the child isn't attending school. Can I ask that clarifying question? Uh-oh, I can't hear you.
Sorry about that. He's in a cyber program, so he's not even in our school.
Okay. And you have received, sorry for the confusion on my face, and you've received notice that this child is in fact attending another school.
While he was attending our school, enrolled in a cyber program, then claimed homelessness, moved to a different school district, saying they're homeless, attending the cyber program, which we were paying. They're still saying they're homeless. So should that neighboring school then pay for that cyber program?
Is the
But we
child,
went through the process. We went through the whole process here, and they did not respond to us. So what's the next steps?
is the cyber program like an approved private school, or is it like a cyber program run through the district?
PA
Sorry, I'm just trying
cyber.
to figure out whose program is this program? Is
It's
it your
PA.
program?
Let's say it's PA cyber.
Okay.
So
Uh,
they're in PA cyber. They were
uh,
residents in our district, enrolled in PA cyber,
mhm,
moved, supposedly moved,
mhm,
claim homelessness, living in a neighboring district. We were then still paying that cyber program. We then contested the homelessness, sent
mhm,
them all the information. They
mhm.
never responded. Does the district still who pays the cyber program if they have not responded to anything?
So you've done the McKinney-Vento process and the Act 67 process.
Everything.
Then you proceed with the disenrollment.
But the child's in a so we contact then the cyber program and say that they don't live here, went through the whole process, disenroll that child because we're not paying that bill.
Yes, you explain to them that child is not a resident of the district, that you have followed the Act 67 procedure, that you have followed the McKinney-Vento appeals process. I would include all those documents, alert
Right,
them to that.
right.
Because it might be that District B will then take over if they're paying for a slot in the cyber.
Okay.
And I would also make sure that they are actually disenrolled, because sometimes what I have seen is that sometimes a family thinks a child is still enrolled in a school when they're not actually. And this process has happened. There may be an attendance proceeding. So just to keep your own records clear, that's what I would advise doing. If this is a particular situation that is happening in your school or has happened, also please contact your solicitor, because they might have additional letters or additional guidance that they want to do in that case. But I'm really glad to know that you did all of those steps. It sounds like to me that you went through and just checked through those steps, which are all very important for students' rights.
Thank you.
H, there are two other questions in the chat. If you want to address those now.
Yes, please. Sorry, I'm just taking notes about these questions so I can add a slide here. Okay, how do we effectively provide notification if all mail comes back undeliverable? Oops, sorry. I think the very first thing is, oops, sorry, I don't know what is happening here. If the child is still going to school, or their family member is still answering phone calls, seeing if their address changed. I know at my apartment, I have a permanent fixed and adequate residence. Sometimes things just like get lost for weeks at a time, or somebody sticks something in the wrong mailbox. So I would resend. I think you can also send via email, but you do have to have the record of the certified mail at least 3 days in advance. I would also keep the undeliverable notices for your records. I would then contact your solicitor about if there are other things that can be done. I would also check, I know that schools utilize a lot of different systems and they can be complicated. I would pull the address in the systems to see if there's any other addresses that might be listed, because in my experience, sometimes one system updates and it's supposed to update the rest and it doesn't necessarily happen. So that's what I would do to try to provide those notices. And what I will do is I will ask our team as well if we have any suggestions for providing notice via certified mail in these cases. And then I can get
Should get
back to the
Lana
group.
in there from Apollo Ridge as well. She's on now. Okay.
And then there's one more question. Let me see here. Okay. This question says, I have a question about if you give a child a start date and find out the parent was dishonest about living situation, which places them homeless, do we have to accept them? Yes, you do. And the reason why is that, let me show you here. We're going to go back to the McKinney-Vento information. So what would need to happen is that if you enroll a student, so let's say my start date is Monday, you believe on the Friday before that I have been enrolled using false information, what you would do is you would then issue a McKinney-Vento eligibility dispute.
Okay.
Then the child would need to remain in the school until the end of all available appeals. So it is possible that that family could then dispute to the regional coordinator, the state coordinator, and file into court. And during that time, you would have to allow them to enroll. If they are determined not to be McKinney-Vento eligible, then you jump to Act 67 and that process, and you would use this one. You would use the blue and yellow one. So this would be information, false information. You would use this process. So you'd provide McKinney-Vento information, which you would have already provided, and you would provide it again, and then you would schedule and convene the residency, or not the residency, the hearing held under the school's grievance policy.
Yeah, it was really a messy situation. We had a parent would register 3 kids, and she gave the address. It's a family that's in and out all the time. She gave the address of where CYS had intervened, and they weren't allowed to live there. Well, the registration person didn't know that. And as soon as we gave them a start date, she called back and said, "Oh, by the way, we're living in Homer City in a homeless shelter." So it started like a spiral of things. I just wasn't sure how that could be handled because she was dishonest about the start date, and then we had to put them homeless and bus them, and it was just real frustrating.
I think that families who are experiencing displacement or have, things could get really, really complicated really, really quickly. And so one thing that's also really important to remember is, let's see, I'm trying to pull up the right slide, is this, nope, not this. Making sure that it's very clear that enrollment paperwork is serious. And if you do believe somebody has provided knowingly false information, that is not a lawful action. And one thing that I ask families to do for me when I'm working with McKinney-Vento eligible families is if they think they're going to experience a displacement, to let me know, and also let me know if families are like staying in a variety of different residences. The basic education circular is very clear that students have a right to attend in any school district, and there are many different ways that can be satisfied where they have substantial contact. So that could be regularly receiving services, parent has an employment, things like that. And so sometimes it may be that children have the right to attend several different school districts. And so I think getting that clarifying information up front is really helpful. And if you're not sure what to do, I have found the 8 regional coordinators are really responsive and quick at getting information and support. I've also found that families sometimes if there is a concern, having somebody else talk to them sometimes like clarifies the information. Not that you would have done anything wrong, just sometimes having somebody who isn't involved at the level where there have been like daily interactions can be helpful when you're thinking about how to find that information. So thank you for going the extra mile. It sounds like you took the steps needed and really tried to investigate what was happening, because I find like even when families are coming to me, they know they're coming to me because they have a McKinney-Vento question. Sometimes it can take a call or two for families to feel comfortable opening up about their housing situation, because when I do a screen, it is comprehensive. It can feel invasive. And if those questions were to be asked of me, I would be a little nervous. So what I always say is, I'm going to ask you a whole bunch of housing questions. Here's why I'm asking. I'm not going to report you to DHS. I'm trying to screen you for rights. And if you have a question about why I'm asking something, you can ask me to explain, and I'm happy to do so. And if you have questions about what this means for your rights. And we have a McKinney-Vento screen, actually. And so if you think having a list would be good, that's another thing. Sometimes I will give it to families and say, could you look at this and then share with me any information that you think is important. Do you think that that would be helpful in a case like this, or is more of the example that you're thinking about is like, what do we do if we know it's just not right from the beginning?
Well, I think the list is a good idea because I think that's something that we probably need to implement here, because I know certain things, you know certain things, and Tanya, who does the enrollment process, we're working on that so she knows, because there is a section in there that says, "Are you currently homeless?" But maybe digging a little bit deeper might help a little bit, because some of them come through vague. So I think that's something I'm going to have to sit down with the team and maybe see if we could come up with a list and add some more to that enrollment paperwork.
Mana, this is Sarah. We have an example of an enrollment document that I will send over to you.
Okay.
That needs to be included as a McKinney-Vento questionnaire in the enrollment packet. And that's something I know you were monitored for McKinney-Vento and ECYEH this year, probably something that came up. So we can meet sometime. We can set up a meeting. I'll email you.
Okay, thank you.
You're welcome.
And if you're interested in another screen that also has the Act 1 questions, ELC has a free one. I use it all the time. I had the questions in my head because I do this all the time, but I find I like a good checklist, and then I make sure that I'm not missing. And Education Law Center actually screens any caller who rings our helpline for McKinney-Vento eligibility and for Act 1 eligibility, because I will ask a family, are you experiencing homelessness? They will say no, and they actually are. And to just give you a personal example, when I first started practicing, I lived in a really terrible apartment that was actually legally substandard. And so if you had asked me, Paige, are you experiencing homelessness? I would have said, well, no, I have a lease. I pay a landlord. I, in theory, have a place I can go. But if I were to have actually screened myself, I would have been eligible. And so I think that having those discussions can be really helpful. Or asking somebody like, why is that the address that they put down? Sometimes people are told like, oh, you have to put down this address, and that's not correct. And enrollment paperwork is, you can't knowingly provide false information. So having those screenings at the beginning is really helpful, and I'm glad it's already embedded in your enrollment form. That's great to know. And Sarah, if there is an enrollment questionnaire that y'all are using, if you were comfortable sharing it with me, I'd love to uplift it as an example.
Absolutely, we'll do that.
Sorry, that was a very long-winded response. I get so excited about McKinney-Vento. Are there any other questions, or would it be helpful to do a very quick Act 1 primer?
I'm so sorry. I keep hearing kids banging at the door. Thank you for your information. I appreciate it.
Of course, of course.
I think an Act 1 primer would be just a good review if you want to
Yeah.
go over those slides.
Yep, absolutely. So let me just move us here. So Act 1 is a state law, and we are actually a model in the country as having this good law that protects students. And it is a law that protects students who have moved at least once during a school year due to homelessness, involvement in child welfare, foster care, or the juvenile justice system, or in court-ordered placements. The purpose of the law is to promote equal access to educational opportunities. Think McKinney-Vento again. Some of the things are very reminiscent of McKinney-Vento. So schools have a legal obligation to identify young people, assign them with an Act 1 point of contact, ideally at the building level, and allow students experiencing educational instability the opportunity to participate in extracurricular programs for which they are otherwise eligible. And importantly, it eliminates all ordinarily assessed fees. We know that there isn't a single fine-free school in Pennsylvania. And if your school would like to be the first, that would be wonderful. Please let us know. But Act 1 eligible young people can't be subject to fees. And
Small amount.
there
Thanks, Anya.
are
Okay, bye-bye.
also additional protections for students who are in the 9th through 12th grade. So ensuring that they're assessed and awarded full or partial credit for all prior coursework that was completed. There are waiver options and there are 3 diploma options. So this is the order that the diplomas always go. Your current school, any prior school, or a Keystone diploma, which is at the state level as a last resort. So who is protected? Kids in kindergarten through 12th grade who experience educational instability. So changing a school entity during any school year, it says a school year. So it doesn't have to be this one. It doesn't have to be last one. It just has to be a school year due to any of these reasons. So experiencing homelessness, involvement in child welfare, juvenile justice system, or voluntary placement or custody agreement. So that may be that, let's say I'm going to go live with my aunt and DHS is saying that that is a voluntary placement. That would count even if I didn't formally enter care. Students may attend school in a variety of settings, including residential placements. They might be returning to school, starting a new school, or re-engaging after an extended absence. And again, protections in the 9th through 12th grade that are expanded. School entities are responsible, and that's broadly defined as school districts, charters including cyber charters, intermediate unit, and career and technical schools, and all have to provide supports for students who experience educational instability. There are many ways to determine Act 1 eligibility, and schools must be flexible based on minimal documentation. So that could be through a letter, email, verbal confirmation, or other documentation. It can be provided by caseworkers, shelter providers, outreach workers, probation officers, others, lawyers. There's no durational cap on eligibility. That means if a student is eligible this year, they will be eligible until the 12th grade or their graduation, or when they age out of the entitlement to attend school. Eligibility must be kept confidential, and students or caregivers can decline to share information with the school. I wanted to go over some of the practices for students in 9th through 12th grade since this is graduation season, some of my favorite time of the year. School entities must honor all previously earned credits, full and partial. I have found sometimes that records come and they're not always as organized, or they're missing records actually sometimes. So what I like to do is sit down with the child and with, if there's somebody that knows the child, and sort of go through what schools they attended when to make sure that all of the records are there. Then there needs to be a credit verification, and investigating whether a course with a different name at a prior school may count as a required course at the new school is really, really important. We have many, many LEAs, nearly 730 in Pennsylvania, and all of them use different course catalogs. So this is a real example. Mythology 1 in one school is actually English 9 in another. So asking a student what they learned, and if your school has a course catalog, sometimes students are able to say, yeah, I learned that, or no, I haven't learned that yet. And then you can come up with an opportunity for them to make up that credit or have that credit waived. You can waive a course needed, including mandatory courses for graduation, if a student can demonstrate competency or if they have completed coursework at another school. And if the course isn't waived, schools should provide an alternative or modified course of study to assist the student in finishing school by the reasonably calculated graduation date. There are many ways to demonstrate competency. That could include a project, a test, a presentation, a series of assignments, or a completion in an experiential learning opportunity, internship, or CTE course. So let me give you an example. I represented a student who was part of an educational advocacy program. That student learned how to make speeches, they learned how to write an op-ed, and they were published in a local newspaper. That student needed a speech credit, right? They could demonstrate competency that they could write a speech, design a speech, and have effective advocacy. I represented another student who was missing a credit on family and consumer sciences, but that student worked in a bakery. So they had to help fulfill orders. They had to learn how to write checks to vendors. They had to make a cake. They had to engage in customer service. They had to engage in food safety activities. That would be another way to demonstrate competency. Folks are looking for partial credit examples often. And there is one in this slide deck. What I am going to do is briefly go over some examples. And when you get the slides, there is a partial credit example with a nice little matrix so you could see one way of calculating credits. Schools have to have a policy around awarding partial credit. That is required in the law. Partial credits need to be awarded even if a student leaves before a marking period. Schools could consider combining the total number of periods a student was able to attend, including periods where they had an excused absence or weren't able to attend due to a school-based barrier or other barrier like attending court, enrollment delays, technology, transportation, etc. And then schools could round to the 0.25 credit hour and can consider the best interest of the student when making credit decisions. Sometimes the math just doesn't make sense because different entities use different formats. So for example, I represented a student who had 1.99 parts of a credit and they needed 2. That was going to prevent the student from graduating. You are allowed to do rounding in the best interest of the student. Some schools use the term marrying credit. So that's like merging the credits. That is a process that needs to be done. And we know that it's being done effectively across the Commonwealth to provide supports to students. And with that, I can see we're running up on time, and I just wanted to provide the quickest primer on resources. So here are the resources. I am somebody that likes categories. So we first have your Act 67 resources, which is going to have the 3 notices, which are going to be attached, all of the resources that were linked in the Act 67 slides in one place. So that'll be the basic education circulars from Pennsylvania Department of Education and all of ELC's enrollment-related resources. We then have a section on McKinney-Vento, which includes information about dispute resolution. So if you wanted to know what the basic education circular says and you wanted to have a slide which talks about level 1, level 2, and level 3, all of that is here for you. We then have Act 1 resources, which includes a link to the law, Pennsylvania Department of Education resources, and hot off the presses as of yesterday, they launched a beautiful Act 1 website, which has a bunch of resources and a place to get technical assistance and to share success stories. So if you have them, please uplift them. This is a season where we can really celebrate student success and the successes of those who have been supporting students all along the way. I also included attendance resources. Sometimes in the enrollment context, there are questions about students' rights under attendance law and when students need to be disenrolled and what the 10-day rule means. If these are questions that are on your mind, we have a whole compendium of resources in addition to a smaller section on the rights of students in care. Fear not. If there is something that I mentioned or talked about that you were like, is there a resource for it? Probably. Education Law Center does a back to school guide each and every year, which has over 60 Know Your Rights fact sheets. And I think we're nearing 20 or 25 self-advocacy tools for students and families. Here is a short list of all of the different kinds of topics and subjects we have. If you're interested in subscribing to our newsletter, that is one way that you can get the back to school guide. I can also be sure that I share it with Sarah. No pressure to subscribe. If you do subscribe, you'll get a monthly newsletter and then the back to school guide. But again, there are ways for you to get it. It is free on our website if a listserv and a newsletter isn't for you. If you have questions, again, please contact your solicitor directly. If you have generic questions about the law, or if you're like, wow, I think a resource or a training like this would be helpful, and you want to bring us to you, we do offer trainings to the community, and you're welcome to share the recording as is permitted by the scope of this here. Here is my email address and my direct. If you ever call me direct, we have a new phone system, so you'll hit my voicemail, but I promise I will call you back as soon as possible. If you do reach out, again, please direct all specific questions about the law and about particular students to your school solicitor. Thank you for investing your lunch period today. I'm happy to stay on if large format questions aren't for you, but you have some. And thank you so much for the kind invitation. I really appreciate your time and attention today.
Thank you so much, Paige. It's such valuable information, I think, for all of, I think I could speak for everyone that this was certainly needed in our region. I am no expert in Act 67, and Irene and I are doing our best to, answer questions. There was one other question in the chat from Nancy that I think could use your expertise as well. So it was about a child living with one parent and then moving to another parent's home in another district.
Yeah.
Yes.
Can you hear me?
Yes,
Yeah.
I can
Okay.
hear you.
Hi, thank you, Paige, for this wonderful training. I just wondered if a child is in our district and I work at a high school and chooses to go live with a different parent in another district, which is near us. But of course, we usually find out they don't disclose it. They're either transporting themselves, driving themselves, whatever. But if we find that out, normally unless they're a senior, we usually let seniors finish out the year with us, no matter what. But if they are in a different district and it's a lower grade level, we try to encourage that student to get enrolled in the district they're living in as quickly as possible. But I wonder if there was any legal issues associated with any of that.
Yes. So this is an it depends answer. So the first is there a court order? If so, that's what you follow. And then you'd want to screen for other grounds for eligibility. So that student might actually be McKinney-Vento eligible. So if they were kicked out of parent A's house and now they're living with parent B, they're in the middle of the school year.
Okay.
And if parent B is living in a housing situation that would be considered McKinney-Vento eligible, they then would have the right to remain until the end of the school year in which they have secured permanent and adequate housing. Now, custody can get a little bit confusing. And if you look at the basic education circular on enrollment, there doesn't need to necessarily be a custody order. If a child spends most of the time with one parent, it's not 50-50. So it's above, so it's 51-49 or more with one parent. That's where the child has a legal right to go to school unless there's an order that governs. If it's 50-50, then they get to choose.
Okay.
I think also, Nancy, with Paige's response to it depends. If we look at what the Beck says for McKinney-Vento and unaccompanied homeless youth, if there were problems in the home, that's something that your homeless liaison would need to investigate the reason, because that child may also be an unaccompanied homeless youth. If parent B did not have any custody of that child and they lost their fixed, regular, and adequate in the first place.
Okay.
Which school district are you representing, Nancy?
Du Bois.
Okay, that's what I thought, but I just wanted to confirm. So thank you. Does anybody else have any questions for Paige, myself, or Irene?
Do I see a hand? No.
Do you see my hand?
I see your hand.
Okay.
Sorry, I couldn't tell if I saw a hand or if somebody was just moving around. So I wanted to make sure I wasn't missing anybody.
Okay. All right. I don't see, there's no further questions in the chat. Of course, everybody, email myself or Irene with McKinney-Vento questions. If it is regarding Act 67 or Act 1, I will reach out to Paige, or you certainly can do so as well. Well, it looks like, sorry. Okay. But I think I think that's it. Okay.
Well, thank you. And I hope everybody has a good rest of your day and gets through the 3 o'clock energy slump. Sending everybody good energy.
Yes, thank you, Paige, so much for being here, and for this extremely useful information. We appreciate you.
course. Thank you.
Thank you. All right, folks, I am going to send out the recording as well as the PowerPoint later on this week. So please look for that email to come from our office. Thank you all very much. Thank you, Paige, again.
Thank
Thank
you.
you. Bye-bye now.